Brookdale Physicians v. Department of Finance. And give us 1 minute. And we are very happy to be joined by our colleague from the Second Department, Justice Valerie Brathwaite-Nelson.
Good evening, Your Honors. Adam Dembro on behalf of the respondent appellant, the New York City Department of Finance. If I may, I'd like to reserve 2 minutes for rebuttal.
Yes.
Thank you. Your Honors, neither Section 420-A of the real property tax law nor any of this court's decisions construing that section permit a for-profit business enterprise to lease property from a not-for-profit corporation and maintain a tax exemption on that property.
Counsel, when we were here last so long ago, we talked about your email and the reason given, it's I think A55. And just to be clear, that is not the basis you're arguing right now.
That is the basis. That is part of the basis that we are arguing right now.
This, it seems to me, was based on rent calculations and whether or not that exceeded your costs, their costs, right?
Yes, that's correct.
But that's not what you were just arguing. Is this accurate or is it not accurate?
So it's, let me take a step back. In that email, that April 2017 email, the Department of Finance characterized the trial court's 2014 decision as requiring that Brookdale Dialysis be treated as a not-for-profit. And the analysis concerning the rents versus expenses that followed was a result of that mischaracterization. It's an understandable mischaracterization.
But it's a mistake.
I'm sorry, yes. That is not what the trial court decision held. Yes, that's
Right.
correct.
So my question is, if you have a nonprofit that's been operating for 20 years under this exemption, and then the city comes in and says, you know, you're leasing to a for-profit and that's not allowed and blah, 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 and you send this notice to them and they consult with their lawyers and the lawyers say, no, you're not doing that. You should challenge this. You should spend the money. You should go to court. You should take up court resources to challenge this. And then you get to court and you say, you know, that was a mistake. Actually, your religious purpose isn't really a religious purpose and you don't get the... Why are you able to do that? What would the policy reason be, the legal reason we would find that your agency can send a notice giving one reason and then come into court later when they make a decision on whether or not to challenge it and change?
Well, first of all, Your Honor, the reason we can do that is because Brookdale Dialysis actually got a much more favorable consideration based on that mischaracterization than they would have otherwise, because Brookdale Dialysis is a for-profit business. A for-profit business can never operate on a tax-exempt property.
And so,
I'm sorry, go ahead.
the appellate division says that it is a for-profit business in this case, in the order under review, right?
That's correct, Your Honor.
So what do we do with that, taking Judge Garcia's concern into account?
Well, first of all,
Because the appellate division essentially disregarded I wouldn't say disregarded. The theory they proceeded on is a different one that doesn't really have to do with the costs, right?
That's correct. In fact, the appellate division did find that the rents exceeded the expenses.
Yeah.
But the first department was correct in that Brookdale Dialysis is a for-profit enterprise, but the remainder of the first department's analysis was incorrect. So what we're here challenging is
Right, I mean, I guess my question is, suppose we agreed with you about that, right, that the remainder of its analysis is incorrect, but that was not the basis for the administrative decision at all, not mentioned the administrative decision.
it actually was part of the basis of the administrative decision.
In the earlier administrative decision, perhaps?
Well, so the 2017 decision in that email references the 2014 trial court decision. And when,
And so does that bring up that previously, I mean, there could have been an appeal of that 2014 decision.
there could have been,
There
yes,
wasn't.
correct.
So why is that then part of the record in this case?
Because when Brookdale Dialysis brought its second Article 78 petition, the 2017 petition, it argued that it was qualified under 420-A1. And
But that was the opposition mounted in response to the statement that that the reason for the revocation of the exemption was that you were operating at in excess of the carrying costs of the building. And in the hypothetical that Judge Garcia gave you, that was a considered decision based on the grounds that were given. So why do you now have the benefit of going back after they've formulated a litigation plan responsive to the reasons that you gave in that email and open it up to basically new theories to defend the decision?
because they're not new theories, Your Honor. When Brookdale Dialysis brought their Article 78, they assumed, they read that determination as also including qualification under 420-A1. And
That was their argument for why they would still be entitled to an exemption, but when you say I forget the phrase you used, they read it as including that, how do you know that?
Because they argued that in their petition. In other words, to be clear, it's not the case that the April 2017 email only the sole basis of that decision was the rents versus expenses, which comes under 420-A2.
Correct.
When they brought their petition, the petition did not challenge, it challenged 420-A2, but it also challenged 420-A1 by saying, we qualify under 420-A1, so you don't even look
And
at...
the two proceedings were about different tax years, is that right?
The two proceedings were about different tax years, but they were before the same trial judge, and in fact, the trial court said, this is basically the same exact proceeding.
And said there was no res judicata effect. There's
That's
holding to that
correct.
effect.
That's correct.
Which I assume you agree with.
We do, yes.
So let me ask you this. Suppose we ruled against you here. Could you then challenge next year's taxes?
I would say yes, because there always needs to be compliance with the statute to get a tax exemption. And our view is that the trial court both times, and I do realize there was no appeal from that first division, the trial court both times made an error in saying you need to look at the interrelationship between these companies.
If I understood the argument that I cut you off from making, but I think I cut you off because I understood it, but I want to get it clearly, your position is the reason that the issue as to the entitlement is up before us and that we can reach the reasoning of the appellate division is because that was necessarily put at issue by the petition itself.
Yes, that's correct, Your Honor.
So if they hadn't done that, could the appellate division have done what they did? Or would you be bound by what you told them?
The appellate division still could have done that because, as I was just saying, there always has to be compliance with, there has to be compliance, for a tax exemption, there has to be compliance with 420-A. And if there's not compliance with 420-A, then yes, the Department of Finance can revoke the exemption, and hopefully we won't be constantly stuck in a cycle of litigation. But the fact remains is that the statute has some very clear requirements which are not met here, and that's why.
Where does the burden lie?
Here, because the exemption was revoked, the burden lies with the Department of Finance. But I would point out that it's a very low burden here, because again, on the statutory language does not permit there to be leasing to a for-profit enterprise. And so the notion that there was some investigation that the Department of Finance had to do, that they were supposed to consider this, that. They considered all they needed to consider, which is that this property is being leased to a for-profit business, no tax exemption. And even here, even as here where the burden is on the Department of Finance, tax exemptions are still construed very narrowly.
But doesn't that go against all of our case law, adult home, recap, a HESI, like that blanket statement that, are we not now to look at exclusive use? Is that what you're asking the court to do?
No, it is absolutely not contrary to this court's previous decisions, because all of the cases that you just mentioned, adult home, the situation there where use was an issue was you have property owned by an exempt company, a not-for-profit, that is using its own property for some purposes. And the issue there was, is this purpose a not-for-profit purpose? Is it an exemptable purpose? So in adult home, they said, well, you have these programs, you're charging rent for people who are being housed here and getting the benefits of these programs. And the assessor said, well, if you're making money, that's not a charitable purpose. And the court said, well, it is, because you have to look at what they're doing to make the money. But in none of those cases involved leasing to a for-profit company. The only case that this court has decided in which there was a not-for-profit leasing to a for-profit is Krakowski. And in that case, this court said, no exemption when a for-profit business is leasing from a not-for-profit.
As a blanket statement, or is there a further requirement that you have to analyze whether the for-profit's activities are incidental to the exempt purposes of the leasing nonprofit?
As a blanket statement, Your Honor, the incidental analysis only comes into play when you're talking about a not-for-profit using its own property. That's correct.
What if you revoked and told them, you don't qualify under 428? That's all you said.
Mm-hmm.
And now they come in and they're like, well, we do this and we do that and we do that. And could you then say, well, you brought that up, so you have to meet that test because you brought it up in your petition? Could the agency do that?
Yeah, well, the difference, I think the agency could do that, but the difference between the hypothetical you just suggested and what happened here is that the Brookdale dialysis was on notice of the issues, and they had an opportunity to address them, and they did
That was
it.
from the old case.
No, in the new case, because they
Yeah.
addressed it, they addressed it in the new case as well.
I'm saying, at least in part, I guess, that they addressed it by arguing res judicata, right? So they understood that that was an underlying issue.
That's part of the way they addressed it, yes.
And how else?
I'm sorry?
How else did they address it?
In their petition, they argued 420-A1. If you look at
But
the...
again, that goes to my hypothetical. If you just say 420A and they come in and they say, well, we qualify under this and we qualify because we don't really know why you revoked, we're throwing things out because we qualify. Now they've addressed it, even though you just sent them an email saying you don't qualify anymore?
I would say yes, Your Honor. That is not ideal, but you have to, because here you have to comply with the statute.
But here, Department of Finance asserted in the email that the monies paid by Brookdale exceeded the carrying costs, and this was the sole basis for the revocation of the tax exemption. That would seem to be an argument under 420A sub 2. I wonder, can property which is leased qualify for a tax exemption under subsection 1, or is such property disqualified from a tax exemption anytime it is leased and subject to the provisions of sub 2?
So under sub 1, the statutory language does not permit there to be a lease. There can be a lease under subsection 2, but to maintain the tax exemption, it has to be a lease to another not-for-profit, and that's what this court decided in Sisters of St. Joseph.
So you're arguing that sub 1 does not permit a tax exemption here, is that correct?
That is correct.
So then this court, I think you're arguing, would have to evaluate this under sub 2.
No, I'm sorry, it could evaluate it, well, it could evaluate it under sub 1 and say, under sub 1, you can't lease to a for-profit business and maintain your tax exemption.
So if the tax exemption does not apply or is not available under sub 1, under these circumstances, should this court turn to subsection 2?
It does not have to, but it could, because that was when the Department of Finance characterized the 2014 trial court decision as saying you're meant to be treated as a not-for-profit. That was really, what they were saying was, all right, you can lease to a not-for-profit, but there are still requirements that need to be met to maintain the tax exemption, so we'll look at those.
So counsel, in this case, when Supreme Court said, I don't want to paraphrase, the primary use, the analysis done by DOF was incomplete inasmuch as the inquiry does not stop at the fact that the fund receives rent from Brookdale. Rather, the primary use of the exempt property must be examined. Your argument is that is a misapprehension of what A2 permits. Is that right?
That is a misapprehension of what A1 and A2 permit. Because a for-profit, there is no scenario where a for-profit business can operate on an exempt property and maintain a tax exemption. And so the trial court's holding, both trial courts' holdings.
And what was there to alert the petitioner of that fact if the alleged basis is simply the cost versus the profit?
Because you can't look at that email in a vacuum. You have to recall that there was originally a 2013 revocation, and that was challenged in an Article 78, and the trial court ruled in favor of Brookdale Dialysis there. And then there was a subsequent, there was a subsequent revocation, which was then itself revoked, following correspondence between the Department of Finance and counsel for Brookdale Dialysis. And then there was further back and forth about the rent versus expenses. So although there are different tax years involved,
Different litigation. Is there any reason, I don't know, strategic or legal reason why the email couldn't have simply said, we're revoking your exemption because you're leasing to a for-profit entity?
no, they could have said that. That was based on, Department of Finance thought that they could not say that based on the 2014 decision, because it's an understandable mistake, because the Department of Finance's understanding of 420-A is that it cannot be used by a for-profit entity under any circumstances. And so they had this decision from the trial court, and they interpreted it as saying, all right, we're supposed to pretend you're a not-for-profit. And that's consistent with A2. A2 does allow there to be leasing for statutory purposes, charitable purposes, hospital purposes, to another exempt not-for-profit entity, but only if the rent does not exceed.
But that was the emailer's mistake, the person who wrote the email, right? There was no actual holding that in the previous litigation that Brookdale Dialysis was a not-for-profit.
That's correct. That's correct, Your Honor. But it was hard to understand because the trial court's holding in 2014 was not consistent with the statute. It was not consistent with 420-A. And so finance was in a situation thinking, how do we have this decision? It's asking us to do something that's not consistent with the statute. The best way we can understand, the best way we can reconcile what the trial court is telling us to do and what we understand the statute to mean is to proceed this way.
So, counsel, let's discuss the case of Pace College v. Boylan. And that case seems to reflect that a for-profit corporation may lease property in furtherance of the purposes of the owning not-for-profit. and have the exemption fall under subsection 1 of RPA PL 420A. Is that case distinguishable from this case?
Absolutely, it is.
How so?
So in Pace College,
So that's the case that involved the cafeteria?
that's correct.
Okay.
And there, the cafeteria was, first of all, it's important to note that the property was owned by Pace College. Pace College owned the property. It didn't, it had the contractor operating the cafeteria as part of the college's mission. And what the court found there is that given the fact that the cafeteria equipment belonged to the college, the fact that the college had a good deal of oversight and control, that the cafeteria wasn't really open to the public, it was something meant to serve members of the...
Cafeteria served students, but it was also open to others, is that correct?
I'm not certain, it may have been open to others, but it was within the college, so it's not really the same as you don't necessarily need a student ID, but it wasn't like advertising to the public to come in. It was on this floor within the college, and what the court there found is that really the entity using the property really is the college because of the degree of control the college exercises over the operations, because of the fact that the equipment belongs to the college. And so they said the profit making was incidental to the purpose of the college. That's different from here, where there's a lease from the fund, which is not a hospital, which is
Which is a not-for-profit,
it's a not-for-profit.
such as PACE was a not-for-profit.
That's correct, but
And in the PACE case, there was a lease to the contractor dealing with the cafeteria.
yes,
That was a for-profit,
but the difference,
such as Brookdale Dialysis is a for-profit here.
but the difference is, well, there's two differences. Difference number one is the cafeteria operator was fulfilling the purpose of the not-for-profit. That's not the case here. The Schulman Fund is not a hospital.
So one of the problems that I see with that argument is that there is no evaluation in the record for this court to view concerning the use of the premises, of the facility.
Respectfully,
And that's something that the Supreme Court pointed out.
well, the problem is, what the Supreme Court said is that you have to look at how the use of the property interacts with Brookdale Hospital and the Nursing Institute.
Right, and that's what you seem to be pointing out to the court here. You're making a use argument, I think. But there's nothing in the record that permits this court to review the use.
Well, the difference is the use is for profit. And I know you're saying, well, what about Pace College versus Boylan? But there, the use became an issue because it was a small part of the college's operation. That's what the court found, that this is incidental. Here, the property is 100% used for a for-profit business.
I think
And-
what Justice Braithwaite Nelson is saying, though, is that analysis wasn't done. It may very well be that it's unlike PACE because there are certain factual differences, but because those weren't the stated grounds, and because that wasn't the nature of the investigation conducted by DOF when it decided to revoke, the reviewing court has no basis to know that.
Well, the reviewing court knows that it's a for-profit business. I mean, that was never in doubt, and that was the basis of the 2013 revocation.
So was the lessee in PACE.
But the lessee in PACE had a much more, it was not operating on a separate location, running a separate business.
Let's
It
hear
would-
for, I'm sorry, let me hear from counsel for Brookdale. You have your rebuttal.
Yeah, thank you.
First of all, to follow up, he made a blanket statement, a for-profit cannot lease to a not-for-profit. You've got Tartikoff, Court of Appeals, Pace University, Court of Appeals, Shrine of Lady of Martyrs, Court of Appeals, and then you have the South Winds retirement case, which this Second Department case.
What's the purpose of the lessor?
In our case?
Yes.
The purpose of the lessor, and if I may, is to according to the certificate of incorporation, is to promote, facilitate, and enhance the delivery of quality, efficient, effective, and economical health care and related services to, and to improve and enhance the general health and well-being of the communities of Brooklyn served by the Brookdale Health System by benefiting, promoting, and furthering the charitable, scientific, and educational purposes of the constituent entities of the Brookdale Health System that are exempt from federal taxes, including
And how would that be furthered by giving a private company a tax-exempt property to run their business?
because they are in charge of funding the companies and making sure that they are providing efficient community services out there. Having a dialysis center, a hospital, for Brookdale in an underserved area serves the very purpose of Schulman.
What if they had rented it, leased it, excuse me, to a supermarket where you had fresh produce? That benefits the community, people are healthier.
The answer
Does
is
that, does that satisfy?
The answer in that situation, I would say no. That goes under the Greater Jamaica case, if you will, where the Greater Jamaica case was, the argument was economic development, and this court held that economic development
But
is
that,
not
I
a
didn't
crime.
argue, I didn't present the hypothetical on economic development. It's, you were talking about sort of, I thought you said the health, access to services for an underserved community. Let's take a community, this is well known in New York City, that those
The
kinds
answer-
of communities don't have access to fresh produce,
I-
healthy food, and so the
I-
lessor decides this would be a good thing.
I would say that, again, it depends on the facts.
Yeah.
You know, you look at, were the people from the hospital working there or not? There are a lot of variations, and each case is fact-intensive. So I couldn't answer the question in that situation. It's sort of like the hypothetical that Judge Wilson gave in the Bauer development case that was recently decided, whether if they decided to put a restaurant to bring people into the hospital, it depends, each case
I
depends
think
on
I
the
asked you
facts.
the last, I'm sorry, I think I asked you the last time, what if it had been an auto repair shop and the facts were that 80% of the people who used it were the employees and patrons of the hospital? And I think the answer I got was that would qualify, even if it was a for-profit auto repair shop.
I would vary that one respectfully, Your Honor.
Good, yeah, that's why we're here.
Okay, I apologize, sorry, Your Honor. I would vary in that situation. If it was just an auto repair shop down the block and they had people from the hospital working there, I don't know if that would qualify, because I'm looking at the Salvation Army case versus Town of Ellicott, where Salvation Army was a charitable proper entity, and they distinguished that case from the Stuyvesant thrift shop case. It's footnote 6, I think, in the Town of Ellicott case, which says that because the people who worked in the thrift shop were the homeless people who got to work and got some money, that satisfied the need of the charitable institution. So again, it would depend on, I'm not trying to skirt the issue, Your Honor, but it would depend on the facts. Just having a repair shop there and the people 80% working, I would say that leans towards a no in that situation. But, you know, this is not that fact. Here, you have an entity that is in charge in the community, that is underserved, is running a hospital, is running an institute, has the funds, and someone's got the
So
control.
then
to
that
do it.
private company...
And that's the Sirogi case.
Yes, so then that private company, because they happen to rent from that lessor, gets a tax benefit versus the private company a block away who's providing dialysis services, who is not renting from the not-for-profit. It strikes me that that is not what the legislature intended.
Well, the legislature has had a lot of time to revise, because in the last 40 years, you've had many cases, and I think 19 of the cases out of this court were for the taxpayer, and if that was inequitable, as we heard the first argument today, the legislature could have modified that as they did in 1948, 1971, to cover for that situation. So it's up to the
Well,
legislature to be
that
able to
assumes
change.
that the current statutory framework doesn't cover the situation.
I
This is
think
my
it does.
point. I
think-
don't see how the statutory framework permits
I think-
this example.
I think after this court's decisions, Southwind's retirement is a perfect case where they deal with the Pace University case, and that was a hair salon, and the second department explanation for why it did get the exemption was because it added to the dignity of the retirees in the house.
And again,
So
I don't,
each ca-
that seems to me
Sorry.
that the fact that on a university campus, you want food easily accessible to people who are running from class to class and may not have food easily accessible to them, sort of seems very integral, makes some sense, and the profit is incidental to the main mission of the entity, the lessor. But in this case, I find it very difficult to see
Your Honor,
how
respect-
for-profit dialysis
Your Honor-
fits the same bill.
Sorry, Your Honor. Respectfully, if a cafeteria, Pace University logic,
Yes.
was that kids have to eat, if the Southwind's retirement logic was the people there need dignity for getting,
Yes.
fixed up and feel good, I think clearly a dialysis center in a hospital down the block is integral to
But
the
it's not
function
the
of the
hospital.
hospital.
That's my problem with your argument. There is not that nexus between the lessor's purpose and why they have a not-for-profit status and what the for-profit, the services, the for-profit is delivering. I don't disagree with you. Of course, the dialysis services are important. That's not my point.
I understand, Your Honor, and that's what the Sirogi case came along.
Mm-hmm.
Sirogi, the owner of the property, was not a hospital. It funded the Sirogi certificate of incorporation is almost similar to the one that we have here. And the court there, this court, found that they were the, quote, alter ego of the hospital, and therefore they were entitled to
But
exemption.
here, aren't they a fundraiser? Don't they
They
raise
ra-
funds as opposed to do work that's really, truly an alter ego of a hospital that provides medical
You know,
services?
They did exact same stuff that they did in the Sirogi, and yet this court found that it did meet the exemption. And if you look at the language in Sirogi for the certificate, you come out with the same language. If I can now answer just a couple of the issues that were raised by my adversary, if I may.
I wanted to ask you about
Sorry.
a point in your brief. The brief indicates that Brookdale Dialysis has not occupied the premises of Schulman since sometime around 2019, and that there is now another dialysis entity that occupies the premises.
Thank you.
It would seem that the issue of how the property is being used by Brookdale Dialysis and the tax-exempt status of the property may now be moot. How do you respond?
I don't know, I don't represent whoever is there, but I thank you for bringing up the issue, because what happened in this case, and this is the problem here, is we win, we win, we win. We then get a notice of tax lien from the Department of Finance that they're going to sell the property, even though we won, they're going to foreclose on the lien. And we had to,
But with respect to my question,
I'm sorry, Your Honor, I apologize.
Brookdale Dialysis has not, according to the brief, occupied the premises since 2019. They presently are not on site, and they have not been there since about 2019.
Correct.
There may be another facility or another entity occupying the premises. So with respect to the issue that is before this court concerning the manner in which Brookdale Dialysis used the property and the tax-exempt status, is that issue moot?
It is not moot because we, Brookdale Dialysis, went and paid the taxes under protest. We were under subject to be sold out. So we went and paid the taxes with a right to go back to the Department of Finance if and when we win to collect that money. So the issue is not moot, because if the court were to affirm the appellate division, My next move would be to come to the Department of Finance and say, now we are entitled to get our monies back that we paid. So the issue per se is not moot. It may not be applicable to whomever may be there, and if they decide to serve them with a non-exemption revocation, it may not be moot as to them. But as to my client, the issue is very much alive as to their rights.
And
I don't know if I've
Brookdale, just to
answered your
confirm,
question.
Brookdale is actually not in the space.
Brookdale Dialysis has left the place, if I may. If I may just touch a couple of issues that were raised, if Your Honor. First of all, we heard, and this is an answer to Judge Garcia's question last time around, exactly a year ago, the question that somehow the 2013-2014 order is involved and swallowed into this decision, page 55. But I'm reading from the Supreme Court transcript, NYSEF document 28, page 7. In other words, and this is DOF, standing in the shoes of the owner of the property, the tenant has to be a not-for-profit and operating for one of the enumerated purposes as well. That's the prior case. We are not concerned with that today. And I agree with you that if the court doesn't want to look at it or review the first proceeding, I think it's irrelevant to the present proceedings, because we are here today concerned with the fact, again, not to repeat myself, but he will, the owner is making a profit on the lease. It's a second component to the statute. And they continue on page 10. Judge, this should be the end of the analysis, as you alluded to earlier. The 2013 decision shouldn't come into play here. It shouldn't even be mentioned.
So,
This is-
counsel, based on that, and relating to those questions that were being asked of your adversary, if the court were to disagree with you on the use question, if we were to hold this is more like Jamaica Development or Lackawanna or some other case that goes the other way, would this record support a reversal of the appellate division, or is there a deeper, issue regarding the arbitrary and capricious nature of stating one ground and then litigating a different ground?
Well, under this court's decisions in Medeiros versus Department of Education, and Judge Garcia, Judge Wilson, and Judge Rivera were on that decision, and the Sherbin versus Bosie's case, this court had made it clear. We are constrained to the four corners of the determination, and we are powerless. That's the words of the court in Sherbin. We are powerless to go outside of the four corners. So he may raise purpose, use, whatever it may be. This court has enunciated that we don't go past the four corners. And the determination, as has been pointed out, there's more than one mistake in here. If you look at the determination, they call it, based on the foregoing, the exemption application is denied. This wasn't an application. This was a revocation. And as we all know, the burden of proof is different. So they seem to be going on a wrong line right there.
So
Then they
would
go
you-
into
would
that
you-
income exceeds expenses.
So would you have
My
us-
adversary
right.
said 100% of the property was used for the for-profit. That's not accurate.
So would you have us affirm on a different ground, essentially on the ground that the administrative record doesn't support the assessment of the tax?
If I had the pleasure of writing it,
Yeah.
I would just quote out of Sherbin. If I would quote out of Sherbin versus Bosie saying, we have said that a reviewing court in dealing with a determination which an administrative agency alone is authorized to make must judge the propriety of such action solely on the grounds invoked by the agency. If those grounds are inadequate or improper, the court is powerless to affirm the administrative agency by substituting what it considers to be a more adequate or proper basis.
What I'm asking is, would that apply to what in your view, would that apply to what the appellate division did here as well? So there's a big chunk of
Referring to what Judge Garcia said at the last argument, this court can affirm on other grounds than what the appellate division did, and I'll take that.
But that-
I'll
is that
take an
what you-
affirmance
is
on
that-
another
is-
ground.
But it sounds like that's what you want.
I'll take that argument. So clearly here, the determination that was a quick determination, it's not even accurate, and we ask that the court affirm the court below.
Thank you.
Thank you.
Just a couple of brief points on rebuttal, Your Honor. Under 420-A, there are two, and only two, entities that are of any significance: property's owner and the property's user, if it's other than the owner. All right. Brookdale Hospital and the Nursing Institute are neither of those entities. They are statutorily irrelevant, and to the extent that the trial court and the appellate division held differently, that is a mistake. It's important here because we were discussing PACE, Your Honor, and my adversary mentioned Tartikoff and South Winds. I'm glad he did. Tartikoff was, first of all, it was a license, not a lease, which is a difference. But in Tartikoff, what this court held was that the user of the property is not really the for-profit camp operator. Because of the degree of control that the property owner is exercising over this contractor, it's really the property owner, the exempt entity, that's using the property. It was similar in South Winds, where they said, yes, you have this for-profit business within the retirement home, but it's really a service being provided by the retirement home for its purposes, just like the camp was operated for the camp owner's purposes, just like in Pace College, the cafeteria was operated for the college's purposes, not for its own purposes. Those are all different here, where the relationship between the owner of the property and the user of the property is solely that of landlord and tenant. And that's talking about 420-A. Talking about 420-A2, and the notion that you have to look within the four corners of the determination. First of all, as has been argued, we think the four corners of the determination do include a reference to the prior decision. But even if you look at the determination on its own merits, on nothing else but the A2 argument, yes, it's true that if I may just finish, I see my time has expired. Yes, it's true that the Brookdale Dialysis was not a not-for-profit, but that being treated as a not-for-profit gave them more than they were entitled to under the statutory analysis. So we would ask that the court reverse the first department here and rule.
I'm sorry, I'm not quite clear on this last argument you're making in response to the 420A2 four corners. Could you just explain that a little bit more? I'm sorry.
So,
It's late, I understand, but.
no, I apologize, not a problem. So it was not correct to say that the for-profit entity was to be treated as a not-for-profit entity. But that treatment got it into the rent versus expenses analysis. A for-profit would not have gotten to that point, would not have had the opportunity to do that analysis. For-profit is out under the statutory language of A1. It says property has to be owned by an exempt corporation.
Okay, so that if I'm understanding you, if I'm following you, your argument is that the only way they can rely on 420-A2 is if they comply with a prior, let's call it a condition preceding provision. Is that what you're trying to say?
No,
Oh, okay.
I apologize.
Are you saying that you don't even get to A2 if you really see what they are? They got a benefit of getting that analysis when they shouldn't have even gotten it at all.
Yes.
But two things with that. One, the Supreme Court did decide that issue, right? They looked at the profit issue at Supreme Court and they
Yes.
rejected it. But also, doesn't that go to my earlier point that you tell them you're A2 and they say, okay, we're going to win on that, let's litigate. But now you say, no, you weren't even entitled to that. Maybe they wouldn't have litigated if you told them the real reason.
Well, just to be clear, that wasn't a pretense. That was just a mistake, an understandable
sure.
mistake by the Department of Finance. They weren't trying to mislead them, but
But it's your mistake, right? So you
Yes.
tell them that, and they look at that and they say, we win on that. And they do win on that in the Supreme Court. But now you're saying, no, you don't even get to that because you got a benefit by that. You get out under the first part.
Two things. Number one, Your Honor, it's actually not clear that they won on that, because at the appellate division, what the Supreme Court said was, look at this enmeshment between these three entities, even though two of them are not properly part of the statutory analysis. And then when the First Department affirmed, First Department said, yes, the rent does...
Why, they win in Supreme Court.
I'm sorry?
They won in Supreme Court, though, on that. I mean, Supreme Court rejects the argument on the...
I mean, they didn't address that, really, in the Supreme Court, or I'm sorry, they didn't find that the expenses exceeded the rent.
They found that you had not met your burden.
That's right, but they found that we had not met our burden because we had not looked at the relationship between Brookdale Hospital and the Nursing Institute and the fund.
The use, you had not evaluated the use, and the Supreme Court felt that that would have been appropriate, and therefore you had not met your burden.
Right, but that was an error because the use was known. Everybody knew it was a for-profit dialysis center. There was no question about the use. So to say that when the Supreme Court said, well, you have to look at that use and see whether it's incidental to the hospital does and the Nursing Institute does, all wrong. Only entity that matters besides Brookdale Dialysis is the fund, the property's owner. And there's no connection between the fund and Brookdale Dialysis. Whether there's some connection between the hospital and the Nursing Institute and the fund is, for purposes of the statutory analysis, irrelevant. And the Supreme Court erred twice in coming to that conclusion, and so did the First Department. That is one of the reasons we asked for reversal.
Thank you, counsel.
Thank you.